Thank you very much, Gary, for the invitation, and pleased to be able to address you. So I've been asked to do a presentation. I'm with LawPro. We're the mandatory insurer of all lawyers who practice in Ontario. One of my functions is to present to lawyers on topics and issues that that could result in a claim against them. Our role is to defend lawyers if they didn't do anything wrong, but also to indemnify clients if something did go wrong. And so hopefully, by doing some presentations, raising some issues and raising some concerns, the lawyers and their clients can have a better experience. I'm not quite sure how much you know about NOSI, so I'll give some basic background. I apologize if it's trite for some of you, but I thought we'd start off at least on that basis. The Homeowner Protection Act, the Government of Ontario put in place, received royal assent on June 6th of this year, meaning the law is effective as of the 6th. And so very, very quick passage. There was a provision for, the NDP had put forward a law. The government had tried to, or did get ahead of it and replace it with its own. The Homeowner Protection Act actually covers 6 pieces of legislation, but in fact, the one that's of concern to you is the one that affects the PPSA. And generally what it does is bans NOSIs for consumer goods. And that is the first issue that comes up. Because the question now becomes, and this was a compromise. The government initially went in, and the NDP proposal was to ban all NOSIs, period, end of story. So they've been preserved for commercial purposes. But where's that division line? And I think that's going to be a question that's going to be coming up. In fact, Michael and I on our presentation next week are exactly raising that issue as to where is that line? What is a consumer good? As much as you think the answer, some things are not as they appear. So as of the 6th, no NOSIs can be registered on title. So you cannot secure as was done before, as you registered a NOSI on title. Anybody who did a search of title, typically when you did some financing or when you were purchasing a property, the lawyer would do a search, and it would be very apparent at that time that there was an interest to be dealt with. Any existing ones, the interesting part is any existing ones have expired. And what does that mean? They're on title, they're there. But in fact, there's now a procedure to delete them. And it's a simple application. Nobody needs to consent to it. Basically, the director of title has put out a bulletin on this to be able to say to the lawyers, any of the parties, the seller or the purchaser, to basically make the application and it be recognized, because in law, they have expired and no longer applicable to title. And so they're gone. Well, that's a good question. Are they gone? The concern, of course, now, so the good news, of course, is that the legislation did confirm that the underlying contractual and financing obligations of the debtor remain. So we removed it from title, but where does that leave us? The concern, of course, is how to enforce these things. For the existing debtors, it really changes nothing. They're making payments. They should continue making payments. There may be some messaging that has to go out to clarify, because the public, of course, may just understand that NOSIs are gone, and therefore all of my obligations are gone, which is not the case. So there may be some education, public education needs to be done by all kinds of parties, and specifically by the creditors. If they stop paying, you should probably have a notice going out immediately to them to remind them that they still have their obligation. The interesting question, though, is, when your purchaser is purchasing a home that has collateral that was or could have been subject to a NOSI, how will the purchaser learn of that obligation? Do they have an obligation? It's an interesting question for the real estate bar as to what due diligence, if any, should be undertaken. The easy scenario, of course, is if the rental collateral is noted in the agreement of purchase and sale, that the purchaser is to assume it. then there's an assignment that the assignment agreement is signed by the purchaser, security is preserved, and things continue as normal. The issue becomes when the agreement of purchase and sale is silent. My question to your members is, has any outreach been done to the real estate brokers and to the regulator of real estate agents as to what their obligation is? They're the ones who are on the premises. They should be asking clients about rentals. They should be verifying, in fact, the existence of any rentals. And so how do you determine that? Of course, you'll ask the client, but clients don't always have the best memory or the best recollection of what they're actually paying. The interesting question becomes is that, if there's an ownership sticker on the collateral, is that notice to anybody, to the agents, to the owners, to the sellers, to the purchaser, that basically this is maybe a collateral that needs to be addressed? And so that'll be the question that comes up. If the notice is deleted from title, the question becomes also, you do a search of title. As a lawyer, you're supposed to get the PIN with all the deleted documents. That's a standard requirement to ensure that there's been no fraud on title, because typically what you have is a mortgage is registered, discharge, another one registered, discharge, another registered. And so if you see those in quick sequence, that's an indication there's fraud on title, and there should be some inquiries made. So having done that, getting that PIN with the deleted documents, and you now see a deleted NOSI, is that notice? Should the lawyer be acting on that? Should they be inquiring of their clients? And this is all new. And a lot of this is going to be new because we just don't know. This is all very, very quickly change. There is no protocol. And right now, there is no standard protocol for lawyers to do PPSA searches. So assuming that you have not registered it on title as a NOSI, you registered a PPSA, when you're doing residential real estate transaction, a lot of lawyers don't do a PPSA search. And so the question now becomes, is that going to change? Now, the other problem that raises is the search. What name are you searching? The name that is registered under PPSA is probably not the same as the one that's registered on title. And so if I'm a purchaser's lawyer, all I see is the seller's name. I check the PPSA against that name. Nothing comes up. Am I in the clear? And the question becomes, is that the proper name that it should be registered under? And therefore, have I done a proper search? The question is going to be as to whether or not the seller's lawyer should be doing. The seller's lawyer will have the information. They have the client. Now, of course, the question becomes as to what is the proper name to be registered under PPSA. That, is still a question to be asked and to be dealt with. And so, these questions are coming up. We don't know where they're going to end up. The purchaser who buys a property, however, without any notice of any collateral that has been secured in any other way, is probably free and clear of any obligation to make a payment. The seller obviously is not. The problem is, where do you end up? As a creditor, as a lender, do you go after the purchaser? That's going to frustrate them a whole bunch. And you may not get very far with it. Of course, we don't know what courts are going to do. We don't know what notice is. If you go after a purchaser and say, but there was a sticker on the furnace that said that it was owned by, that was sufficient notice. Is a court going to agree with you and accept that? Or are they going to go by the Goods of Sales Act, which says that basically purchaser for value without notice is free and clear? There's no doubt that there's a case against the seller. And immediately after the sale, there's typically a bunch of money there, but they typically doesn't sit in their bank accounts for very long, so it's gone. If they've sold and and given away the money or put it into something else that cannot get it, how do you get that money out? So those are going to be all interesting questions that we have. The lawyers have them right now. We are trying to address it as an insurer. We are interested in what the protocol will be. Some say, well, there's title insurance, and so title insurance will take care of it. Well, title insurance is not the end all of everything. Title insurance covers title. And so does this collateral affect title? Well, in fact, the ban says that the NOSI is expired. And so there's nothing on title. And so how do you, and it may be, that's a question still to be answered as to whether or not, if it was there before, if there's an obligation in the contract if registered on title, is that change the scenario? It'll be interesting to see what, if that gets to court. But I think the easy answer for title insurers is going to be, it's not a title matter, we don't cover it. And so, the fallback is going to be probably at that point, action against a lawyer and maybe, fall on LawPro's lap. So we're looking at all of these issues now, but interested also to find out what are lenders looking at doing? What are your options now? Presumably you could register a mortgage on title, which is kind of the same issues you had with a NOSI. You could register a notice on title. I guess you could register a notice of the lease on title. The problem with notices, of course, is that they typically just fall under Section 91, Section 71 notice. And that's all it says on title, Section 71 notice. And many lawyers don't look at those because they say, well, if it's not specific, we don't have to look at it. And, does that change the title insurance view? Does that change things? I don't know. I think a lot of questions are up right now. And as I say, anxious to hear any questions that you have or to have further discussions on this. Turn it back to you, Gary.
Thank you so much, Ray. I think that must have stimulated a lot of head scratch in the crowd. I know that we have been speaking to the title insurers, all the major title insurers over the last week. I think you're absolutely correct that they're going to say this is out of our domain. They've already said that to us. Anybody in the group have any questions for Ray? Any clarifications? You're on mute, Jordan. You're off mute. I hear you. Okay. Any other questions while Jordan gets his audio in line? Because I know that when Jordan gets his audio going, nobody's else is going to have a chance to speak. Jordan?
How about now? Does it work now?
Yeah. Okay. Too late, everybody. Jordan's got the mic.
Thanks for that, Ray. I think Ray did a fantastic job of covering a lot of the intricacies of it and the questions that are to be asked. I mean, the reality of the situation is that the government has focused on looking good, but not actually really doing anything, and they've created more of a mess than anything else. They ignored industry concerns for 10 years on this. I remember talking with the industry, with the ministers back in 2018 about making adjustments to, get rid of any sort of bad actors to ensure that the longevity of the space, and they just didn't care, at that point in time. And there was a bit of news coverage that prompted them, McCarthy to take this up, and they effectively kind of just rammed it through in second, third committee and royal assent all in an afternoon, all in an hour actually, just before they got on to holidays. There was actually one member of parliament that did stand up, provincial parliament did stand up and really address the fact that this bill was embarrassingly bad in terms of how it doesn't consider any sort of outcomes that will come from that, and really throws the baby out with the bathwater. and
then went on to vote to let it to vote for it. So unfortunately, this is where we are. So, but I know that Jordan, you've been on a few calls with me, and we've been, speaking to title insurers, etc. What are your thoughts?
My thoughts are that I've read the title insurance policies in depth, and I do think they actually have exposure in a few different ways. Some of the policies have endorsements that talk about off-title searches, talk about unregistered and registered instruments, like in the context of off-title. And the reality and the most misunderstood thing is that with the NOSI, that was just a notice of a security interest, and that security interest was registered under the PPSA, and Section 54 that PPSA allowed it to be registered on title to give proper notice. The government's made it clear that they're not addressing the underlying security or the contract or the security agreement or the contractual debt either. So the problem is all they've done is just basically remove the tools for lawyers to be able to do a good job and for purchasers of subsequent interest to be able to do their job. I think where it gets interesting is that whether they're to know or ought to have known, if somebody pulls a deleted search, sees that there was an application general produced for the deletion of security off title, is that notice? Well, they should certainly inquire to see whether or not there's still an active account, because one of the most common examples is somebody purchases a house. The agreement between purchaser and seller is that everything will be paid off. The bill comes out, then the seller's lawyer, somewhat misinformed about the whole thing, takes the position of, I can just delete the security off here and save my client some money. That debt would remain with them. Well, and then they transfer the property over clear of title. Well, that's not actually really the proper case, and that's where I think title insurance may have exposure, because if I were a buyer of that house, I'd say, no, our agreement was for you to pay off the furnace, the air conditioner, the hot tub, whatever items were financed here. All you did is just wipe the title, but now we've got people with a PIMSI or other form of priority interest that is registered in the appropriate registry, which is the PPSA, taking priority over that item. You've been provided notice because you, as the lawyer, actually filed an application to delete such notice. There wasn't an expired banner on it. It was deemed expired, but it did exist. And as such, you should be, me as the client, I'm going to make a title insurance claim, and I'm going to say, you need to go sue the lawyer for their, or the seller, for breach of contract and for not doing their job properly. And I think that's where title insurance is just going to, even if they deny a lot of the claims or there's partial coverage for the client, they can make changes moving forward. But because this was a retroactive matter, they're just going to have an administrative nightmare. I mean, a $500 to $1,000 a policy that they've issued that has 10 plus years of coverage, and now all this happens. There's so many rental units out there that the only appropriate resolution in my eyes, and the title insurances, they agree, they're just kind of, nobody wants to take the first step, but some of the title insurance companies we've talked to are already looking to discuss with the electronic companies that produce the conveyancing, standard form conveyancing documentation, to make adjustments to that documentation to actually reference this, and quite simply to sub out NOSI for PPSA in terms of the standard practices, where now there'll be a search done on the seller. And as Ray mentioned, that's kind of problematic because the naming can be a bit different. I think that luckily there is some non-specific search that can be done quite inexpensively that allow that information to be discovered. But I think that's simply just the best practice that would have to happen given the scale of 1 in 10 homeowners. The other issue is that every single brand new home in the province is built with a rental water heater, every one of them. And so that's an issue as well for first mortgagers, because any sort of first mortgage provider is going to be taking over something that has a priority interest in that leased piece of equipment that didn't belong to the house and was excluded from the sale as well. So there's going to have to be some changes there in terms of, should that be marked inventory under the PPSA and some other intricacies. But to sum things up, I think that, the best thing would be in the natural course would just for for PPSAs to be noted. And if the industry does a good job with self-regulating any sort of bad actors, which we're talking to some of the larger parties like ESC about ensuring that any of the smaller parties that cause this issue, which are mostly out of the business for a long time from now, have been out for a long time, that they are not allowed access to abusing this system so that we don't have a repeat of the NOSI situation in a few years from now.
Yeah, and thank you, Jordan.
Comment on that is that there's a standard closing document, which is the vendor's closing certificate, and it basically has a bill of sale, and the bill of sale is from the vendor saying, I own everything free and clear, and I'm conveying it to you. And so from the purchaser's lawyer's side, yes, there may be something on title, and I agree that those questions come up as to what do you do with that. But you get a document from the seller that basically signs saying, I own it free and clear, and I'm conveying it to your purchaser. That brings up the question as to what the seller's lawyer is doing. How much time are you spending with them to clarify? Because I know that when I used to sign clients up, they just wanted to sign on the bottom line and leave. Give me the key, give me the check. That's all I want. They get frustrated with the time that you spend trying to explain the documents that they're signing. So that'll be a question to see as to whether or not sellers' lawyers pick it up more there to deal with. But again, I think it comes down to the agents, the real estate agents. That would resolve everything, because if you have a real estate agent putting on the agreement of purchase and sale that it's a rental, that's the end of the story. The purchasers has it, and whether you have a NOSI or not, it's there's an agreement to continue it, and I think that's maybe an avenue. I don't know if you've explored that, going to RICO or going to AREA and talking to them about what are their agents' obligations, and are they reminding agents of that obligation?
Well, what we found is that
can we Jordan, can we just let Diane just chip in?
Hi, all. I'm actually here as a transactional real estate lawyer and member of the CLA for a couple of years now. So to Ray's point, absolutely, there is a paragraph in the closing documents that the vendor, the homeowner, is signing related to a bill of sale. I would venture to say there are many, many homeowners that are unclear about what some of the monthly payments they're paying on equipment, whether it's a rental, a financing payment, is it a maintenance fee just for annual maintenance? And I'm just talking about all legitimate contracts. Obviously, we're not talking about any companies that have shady business practices. So I would suggest that, as Ray mentioned, when a real estate lawyer like myself is meeting with a vendor client, they are signing these documents honestly, but there are many opportunities for them to be misinformed. I also am hesitant. So of course, all of the real estate agents in Ontario need to be informed and educated about what to look for, what to ask for when they're doing a walkthrough of a home, about equipment, whether it's furnaces, water softeners, hot water tanks, anything like that. But another high risk area where things can be overlooked. So from my perspective as the lawyer at the end of the day, who's wanting to help everybody get their transactions done, if it were a requirement if I'm representing the purchaser, if it's a solicitor's instruction from my purchaser's bank, their new lender, that I must do a PPSA search, so be it. At least there's an opportunity there for these issues to be discovered. And because I do see significant issues post-closing when something is discovered that the furnace is a rental and it wasn't owned outright. There's going to be many, many issues. Thank you.
No, thank you for that. I appreciate that. Look, there are so many stakeholders that the CLA is obviously happy to herd the cats and meet with all parties, and we're coming out with an educational piece with ESC right now on PPSAs. We'll continue to work on informing the sector as best we can. I think this is the beginning of onward going dialogue. But I think, Ray, you're absolutely right. We have to work out who are the key stakeholders in the ecosystem and who has the hot potato essentially in this journey, and work out strategies, because, you know, we have to essentially jerry-rig something now that when the NOSI's gone, right? Any questions for Ray? A great opportunity for any of you to clarify certain things at this early stage.
I just wanted to make a comment on the realtor thing, if no one else has one. What we've kind of found with that is that a lot of the realtors, there's so much going on in a sale, and like Ray had just mentioned, people are just eager to. There's a lot. It's one of the most high stress things for most people. The home is, you know, they buy and sell the home maybe once in 10 years or greater, and most people are pretty uninformed about the process. And there's so many things that can cause a real estate deal to fall apart last minute, whether it's subjects on financing, whether it's strata fees that were unpaid. It can be a ton of things. And the last thing somebody wants to throw into the mix at all is a water heater or something like that that could be considered a $1,000 item that could be a contentious mix. So we found that, frankly, a lot of the real estate agents just like to brush over that. I mean, the good ones don't, but a lot of them do. So even if they know that there's equipment on there, it's kind of like they don't look at it, and they leave it up to the responsibility of between the seller's lawyer and the client to properly disclose that stuff. That's kind of their court. Their issue is just to sell it and make sure that the property looks pretty and to negotiate a price. And so that's kind of what we've seen with that. And frankly, I think that impact with that would be great, and something along the lines maybe of a slight adjustment to the standard form OREA paperwork. But it already does have Section 9 in there, which is quite specific, and so people basically have to at that point just have a simple breach of contract in order to be ignoring it. And I guess what constitutes notice, if a creditor has done the work to register that PPSA on the province's network and nobody goes to check it, it's kind of commensurate with not checking the title as well if there was a notice that was on title. Obviously it's really screwed up situation by the government doing it the way that they've done it, but everybody now has to know, or ought to know, given the scale, the factors, 3 million pieces of equipment between Enercare, Reliance, and the top other companies alone, and every new home is built this way. I think that it's now an intricacy and a nuance of Ontario that this has to be done in the future. And yeah, that's all I got.
If I can counter that,
please.
To address that, if I look at the agents are making 5% of the purchase price as their commission, lawyers basically don't make the equivalent of the HST on the commission. And so for the agents to be passing that on to say, well, it's too much work for me, I don't sit well. Now, of course, I'm a lawyer, so I'm biased, but and I think Diane will agree with me on that. But basically, I think that's part of the work. And yes, for clients, it's a very troublesome time. It's very much involved. But that's the professional. They've hired a professional, which is supposedly a real estate agent. So if they really are professional, I think they should take their professionalism and do it. And the box is there on the OREA form, but how many times is it not filled in? And I think it's really, now the problem we have, of course, is that they brush it off and it falls on a lawyer, and the lawyer gets sued, and nobody countersues the agent. And I'm just, I'm upset with that, because at the end of the day, most of the problems we have with closings are caused by agents. And, I apologize if there's any agents on the call, but, that's a lot of what we see out there. The other thing about the PPSA, there is no obligation to check the PPSA. There's an obligation to do a search of title. There is no obligation, never been an obligation. Now, some of the good lawyers do a PPSA search, but on residential real estate, mostly because the agents have cut it down to commodity, The prices, the amount that lawyers get is so small that basically they're not doing anything extra. And, we see this all the time. The government keeps dumping stuff on lawyers to say, oh, they'll do it. Well, no, they're not, unless there's an obligation. And again, I hate to see lenders turn around and say, well, let's put the obligation on on a lawyer to do PPSA search, which, is a way to address it. The problem is the problem with the searching, and the purchaser's lawyer is really at a disadvantage because all is you have the name of the registered owner, which is probably not their proper name that they should be registered under PPSA. It's probably not the name that they're registered. It's registered on PPSA. The other thing is it may not even be. They may be the second owner, and so the PPSA is registered against the first owner, who's now off title completely, and so. I agree that in the interim, and I think that's where the discussion has to be had with the industry, is to say, okay, who's best placed here to address these issues, and how do we, minimize the impact on everybody, but provide for coverage for everybody, and that's a discussion I'd like to continue on if we can.
Yeah, no, and we shall. Because I think we're just at hello in this issue, and it's clear as mud. So, we want to at the CLA make sure that we lead the charge on this and help in any way we can. So we really appreciate that, Ray, that you're joining us, and that hopefully this can be an onward going engagement as we brainstorm and come up with strategies.